we need to take this one off before I start.
The application is not necessary, we were told this morning. I was rather surprised it was listed, so I'm glad somebody else spotted it.
Good.
Permission is given.
Yeah.
In the event that we look at any of the more than 350 pages, permission is given.
Well, I'm sure we probably won't look at all of them, I'm sure, but we negotiated quite heavily with the Court of Appeal on the number, so we will hopefully use the time judiciously.
Yeah, okay, good.
My Lords, I appear, as I did in the court below, for the appellant, Mrs. Philipp, and my learned friends, Mr. Goodall, the Queen's Counsel, appears with Alexia Knight, who also appeared for the bank and court below. That is Miss Knight, but not Mr. Goodall. And Mr. McElroy appears for the intervener. The Consumer Association, also commonly referred to as which.
Yes.
So far as housekeeping and timetabling is concerned, I'll proceed on the assumption all is in good order in terms of the materials before your Lordships, unless there's anything particularly you want to raise with me right at the outset.
We've read all the skeletons, we read the judgment. Speaking for myself, I looked at some of the other documents, but so we're well aware of the issues in the case.
Good. So what I propose to do is to give you a brief introduction and outline, and then I, in terms of the structure of my submissions, intended to spend under heading number 1 some time on just looking at the facts and the development of industry practice up to the date in question of March 2018. And then, as a sort of second part of my submissions, look more closely at the propositions and principles which we say are derived from the case law as to why we say the judge erred. So that's the sort of broad scheme I intend to adopt. And for reasons which will become apparent, I will be spending a little bit of time on the initial aspects of it, even though this is an appeal on a point of law, because you'll appreciate it's our submission, it's heavily dependent on
Well, your submission is where the judge made 2 errors. One is that he erred in concluding that on a summary basis that there was no duty. And the other is that he should have let the thing go to trial anyway.
Exactly. So perhaps I could just start with my outline then.
Yeah.
And as you'll appreciate, Mrs. Philipp lives together with her retired husband, Dr. Philipp, in Westbury-on-Trim, a suburb in the north of Bristol. They became victims of a sophisticated authorised push payment fraud, commonly referred to as APP fraud, in March 2018, which convinced them their accounts were unsafe and their money should be moved to FCA safe accounts abroad. They thought they were doing their public duty by doing so, and by doing what they were told by fraudsters impersonating as agents of the FCA and NCA in a very sophisticated manner involving telephone interceptions and devices which reassured the Philipps, notwithstanding their concern and fear as to what was going on. Mrs. Philipp, under that mistaken belief, induced by the fraudsters, instructed Barclays to transfer £700,000 by 2 transfers to accounts in the UAE. I'll come back to the details in due course, but suffice it to say, as reported by the judge at first instance, a large part of their life savings was lost. The banking industry, Barclays Bank included, properly recognised by 2018 that APP fraud was a widespread and growing problem, and that there was a need to take steps to help protect their customers from becoming victims of it. The bank persuaded the judge in the court below, however, that the bank should not be liable for the consequences of APP fraud, even if they fail to take steps the industry recognised should be taken for the protection of personal customers, or in any event, there was sufficient doubt about that issue to require it to go to trial, we say. The logic of the decision below is even if the bank knew or was on notice of a fraud being committed against their personal customer, they were required to make the payment without delay or discussion, contrary to what we say was a proper understanding of the industry practice as contended for by us, even if they knew it was a fraud. We submit that's
so even if there had been a warning that flagged up on somebody's screen that said, "Do not pay money to Lambie Petroleum. This account is under fraud investigation."
Exactly.
On the, you say, on the judge's conclusions, there was no duty to do anything about it.
Precisely. So let's assume someone went in the next day after the balloon went up with the Phillips, and it identified a payment to Lambie Petroleum. On the bank's case, no duty. We submit that's a startling and retrogressive outcome for personal customer protection in relation to risk which the bank is better placed to know about and prevent than the customer. So how do we get there? Well, we've already observed a couple of reasons why we got there, but let me just take a few headline points. Firstly, we got there because the judge was wrongly persuaded the bank owed no duty to take reasonable steps to protect its customers from APP fraud. Indeed, as articulated by him at paragraph 180 of his judgment, other than fraud by an agent of the customer, all other frauds are off limits. He was wrongly persuaded that the duties of the bank acting as a payment service provider was solely a question of law, see paragraphs 114 to 116, to be decided on case law, uninformed by evidence as to current reasonable industry practice, or in any event based on an incomplete understanding of the practice by March 18.
I mean, you get this really weird situation on the judge's judgment day where you, in effect, and it's not absolute, I accept, that the duty only really exists in relation to corporate customers. And the individual customers, who are the very people who most of the relevant legislation and guidance is designed to protect, are left out in the cold.
Exactly.
It's a very odd.
It is an odd outcome to end up at. And even more oddly, you can have a personal customer who does things on their own, is subject to an APP fraud, no duty. But if they instruct, for example, their husband to do the transactions on their behalf, he's subject to an APP fraud, which does give the bank cause to believe that, in fact, that their customer doesn't intend what's going on because their agent has been suborned by a fraudster. They do owe a duty, as I understand their submissions. So we end up, as you said, as you rightly recognise, in a very odd situation. And the reason why we end up there is because he was wrongly persuaded just to look at historic case law, which largely arises in the corporate context for reasons we briefly discussed. And he was also, as a result, wrongly persuaded to ignore evidence we sought to adduce from Mr. Brigton, not to say that this is the final article, but to say, look, we have a realistic prospect of showing that the industry practice at the time did recognise the need to take steps to help prevent the personal customer from becoming a victim of APP fraud in the terms we contended for. And he wrongly rejected that because he concluded it only went to standards. And this was all about duty, not standards. But as I'll come on to, that's not actually a particularly easy line to draw in this case. We say the evidence goes to both. But whatever the rights and wrongs of that, we say that the evidence we sought to adduce was clearly relevant to the question of the issue of the duty before him. And he was, of course, wrongly persuaded, therefore, that we had no real prospect of showing that there were relevant, generally recognised standards or codes in practice in relation to APP fraud at the time. See paragraph, for example, 153 of his judgment. And we submit that part of the reason why we got to the wrong place is because he was wrongly persuaded to treat what we say derived from the Quintscare case line of authority as a solitary island, divorced from the more general principles and more general duty of which it forms a subset. And we can see that in paragraphs 128 to 133 of his judgment. We submit that
what I describe as the rubber company frauds.
Yes.
The two cases, Salanga and Carrick.
Carrick actually was the first case.
Yeah.
Where
it's the same fraud, though, isn't it?
It's the same fraud.
It's the same people.
Yeah.
Same fraudsters.
Yeah.
But if you looking at what the judges said, particularly Mrs. Brightman and Carrick says there, I mean, true it is, it is in the context, if you like, of an agent of the company misappropriating the company's funds.
Absolutely, yeah.
But the idea that the duty would have been, that the court would have said, no, sorry, no duty here, given the facts,
It's just simply
is unthinkable.
It's just simply a product of the fact that it's quite rare to get a personal customer to issue high court proceedings in this context. Of course, APP fraud is a modern phenomenon. It wasn't around all that time ago. The main problem arises in the corporate context is, of course, intimately connected with fraud by the officer. There are other frauds as well. I'll come on to this in due course. And I lodged yesterday an additional authority which just illustrates how the court approaches the issue of fraud and negligence in a different context with the banks, because I just thought that was instructive, just to look outside the Quince care line as well.
Yeah.
But
You say APP fraud is new. I mean, I'm sure the acronym is new, and in the modern world we wouldn't be anywhere without acronyms, but persuading people to pay money into another account is as old as the hills.
it is fraud,
And that's all APP is, as I understand it.
it's a type of fraud, and it's an increasing problem in relation to the modern society. We've had a global pandemic of health. It's not an understatement to say that it's an endemic problem. The amounts of scams which are going on in the country is quite phenomenal. And in fairness to the banks, we're saying they probably recognise that.
The first thing you get if you go online onto your bank is a warning about what effectively is
Absolutely,
APP fraud.
we can all take judicial notice that when we try.
Every payment I make, it says, "Are you sure somebody hasn't asked you to make this payment?"
Exactly. I sometimes get very frustrated that I'm trying to make a payment to HMRC at the end of January and find that I'm in trouble in terms of getting it in on time because I've got to go through all these checks. But it's part of what we already do. So our short point is actually what we're coming to before the court is something rather modest, which is that we're simply saying that we have a realistic prospect of showing that the modern current standing banking practices did recognise the need to protect the customer from this pernicious fraud. There is no proper distinction between this fraud and other frauds. The public policy reasons are the same. And we're not asking for much. All we're asking for is for a consequence to arise out of the duty to take reasonable current banking practice steps. I don't really understand the beef they have about that, because they're already, on our case, recognising that as part of standard industry banking practices. It's not a radical or dramatic step. It just simply arises in a novel factual circumstance that hasn't been before the court. For the reasons my Lord Justice Coulson said, in actual fact, as a label it's novel, but as substance it's been there a long time. And of course you've got the point that overall we say the judge was wrongly persuaded to do all that on a summary basis. No disclosure from the bank beyond initial disclosure, which of course doesn't include the requirement to disclose adverse documents. No evidence from any bank employee or independent expert on their side. There was no evidence from their side to support the assertions which they made in the court below and continue to make in the court, in this court, about what they say is the current industry practices or the adverse consequences of a duty being recognised. And a major wrong turn, we say, by the judge was to conclude that because the Philipps had provided a comprehensive and uncontroversial bearing of their chest as regards what happened, and they sent their police notes to the bank, and because that was largely uncontroversial, he could proceed to determine matters summarily. Whereas in fact, the duty issue in this case is not dependent solely on what the evidence from the Philipps is. They're not part of the industry. It's heavily dependent on the bank side evidence, and in particular current banking practice. And the issue should not have been summarily determined against the Philipps, we say, in those circumstances. So those are my introductory observations. I said I had two headings. The first is just tracing some of the industry points and the background facts up to March 2018, and then secondly the propositions and principles. So starting with the first, I'll try and generally deal with matters chronologically, And of course, when I'm summarising the facts and points below, it's all in the context that this may be contentious for trial. But so if I state things emphatically, of course, I recognise that that's the context in which I'm making submissions. So firstly, obviously, the customer relationship, the contractual relationship between Mrs. Phillips and Barclays Bank goes back to the 1990s. She was a loyal customer of theirs for a number of years. And as you'll see from the pleadings, it's either admitted or not in dispute and recorded by the judge. Mrs. Phillips' accounts were had never more than about 55,000 in them.
How much?
55,000 overall, all her accounts at Barclays. And the current account in question here never had more than £10,000. If you look at the bank statements, we come to them shortly, modest sums of money coming in of about £100 or £50 for Mrs. Phillips, teaching as a music teacher. Dr. Philipp had retired. And I'll come back in due course to the precise circumstances in relation to what happened in March 2018. But before I do so, I want to take you to some general industry documents to show you the progression of the problem and the reasons why we say the judge just didn't quite properly understand. I'm sure the fault was mine rather than his, what we were seeking to say as regards the industry practices and where that took us. So far as the first point I wanted to take you to was September 2016, and it may be helpful for you to have a supplemental bundle in hand, just while we skip through these points quickly, mindful of the observations made at the outset.
Right.
So, which started the ball rolling in terms of trying to sort of raise the flag as to this being an issue in September 2016. And we don't need to look at the document in any detail, but the super complaint which started the ball rolling in this respect is at page 222. And what they were seeking was clearly to improve consumer safeguards in the market for push payments.
Bundle B.
It's bundle, it's supplemental bundle. Mine isn't marked A, B, or C. It's just simply
Which super complaint?
Sorry, within the tabs, I think it's behind tab 5. I don't know if your lordships are there or not.
Yeah.
I'm grateful. You'll see I'll skip through this quite quickly. You'll see that page 225, they identify the need for an investigation, and they, page 229, then summarise the evidence in relation to the features which they perceive in terms of the marketplace at the time and the difficulty for consumers in getting redress for authorised payments as compared with unauthorised payments. And we then, in section 2.4, have a passage which is headed, "Bank's conduct is not justified by any special circumstances of authorised push payments." And I just invite you to note some themes which are still being persisted with now, are considered by which and addressed and rejected in relation to the potential justifications against recognition. Page 231.
231.
Sorry, 231.
Yeah.
Paragraph 2.4, heading "Bank's conduct is not justified by any special characteristics of authorised push payments," which is, I think, the point really my Lord Justice Coulson was flagging at the outset. Really, there's nothing about authorised push payments which justifies treating them as a thing apart. Of course, normally fraud is considered to be a thing apart, generally, not individual categories of it. I won't dwell on the detail of it, but you'll note that that the consumer harm is then addressed in section 3, and then we have the remedies proposed by which at page 243, and And you can see that they propose two options for redress in relation to the customers. Option A is strict liability effectively, and option B is an approach which is more akin to a common law approach of requiring certain risk management standards and a liability potentially if they're fallen below. And there's obviously a call for the regulator to act at the end of the conclusion section at 247. The payment services regulator response is December 2016, and that starts at page 248. And you'll note that I quoted from some passages of this in our skeleton argument, but the executive summary starts at page 250. You might want to just briefly cast your eye over that if you haven't yet done so, but the passages in particular that I was going to invite you to consider carefully were 1.9 and 1.11. Now, you'll note that there's a recognition that it may be said, well, PSBs are not generally liable for APP scams. Notice the word generally, of course. That may generally be true. The focus here is, of course, on statutory protection rather than a close examination of the common law. Yeah. But they note that the existing legislation provides for a number of actions to be taken by the banks in order to protect their customer against fraud generally, and in particular to avoid being a facilitator of money laundering. And our points in relation to all of this, money laundering and this aspect, is really just to emphasise that the regulator and the banks recognise by this time that customer due diligence checks, for example, in relation to transactions above £10,000 or thereabouts, was something they all were already having to do in relation to money laundering regulations. They were already having to consider doing checks in relation to financial crime generally. And so far as electronic banking is concerned, they were required to consider the risk of fraud and put in place appropriate procedures. That's the Banking COBS rules 5.1.10a. If you want the reference for that, it's volume 3, tab 41, E1586. I suspect I don't need to go into this. I'm sure you're familiar with all the relevant regulations. So the point here really is an evidential one, that they're already doing these things which overlap with the risk factors in relation to APP fraud, if I can put it that way. And that's what the regulator recognised here in paragraph 111. And the key paragraph here which underpins this, obviously I have to take you to the executive summary, but the key section which underpins this is section 5, page 281, consumer safeguards against APP scams. And you'll notice the print in the blue box. The available evidence suggests that current legal obligations and commercial incentives already mean that the sending bank's interests are broadly aligned with those of the consumer. And if you see that sentence right at the outset within the blue box. That summary is then was going to then take you to paragraph 5.3, the role of the sending PSP. Note these words, 5.3. We have observed a significant amount of evidence that while specific practices of individual PSPs vary, in general, PSPs appear to make significant efforts to prevent their customers falling victim to APP scams. And then they group that under various headings: monitoring, customer profiling, challenge, checks, prompts, staff training, etc., etc. So, skip through all that summary, 5.26. While specific practices vary, in general, PSPs appear to have developed reasonably extensive measures to help prevent their customers from falling victim to APP scams. So this was December 2016. And for that reason, and then there's the commercial incentives paragraph at 5.27, which is then picked up on in the summary section, which we've already alluded to. So for that reason, when you then come and look at the later materials, they're not talking about this because it's already happened. The bank's already doing these sorts of things. It's talking about how do we design the model? How do we deal with the fact that this model is being contemplated as potentially being involving a sharing of costs between the sending bank and the receiving bank, etc., etc. Because the regulator has already thought that the banking practice is already, generally speaking, whilst there are some variations in practice, reasonably advanced in terms of the practices they are already taking. I wasn't going to then dwell on the later documents, just save to invite you to note that after that, in 2017, for example, we have, I'll just give you the reference, at 219, the UK Trade Finance press statement recognising as an industry body the scale of the problem, over 100 million lost to transfer scams in the first 6 months as recorded or reported to them. There's obviously discussion about improved reporting. I should say, sorry, that the document I looked at, December 16, if you want the reference for it, Barclays was a consultee, that's page 324. All these documents, Barclays seems to be involved as a consultant, I should add. We then have the regulation consultation by the payment service provider in November 17, that's page 334, with some high-level principles noted and indicating that they are now consulting about effectively option B, as suggested by which, but looking at a model for compensation. There is a reference you should note in that document which carves out international payments, and the reference for that is at page 377, paragraph 6.42. So we have international payments which fall outside the code in any event. We then have at 31st of January 18, the Dear CEO letter, which we've seen referenced in the judgement, and that letter, if you want the reference for it, we need to go back within the supplemental bundle to tab 3, page 78 and 79. And this was the then Chief Executive of the regulator emphasising to the banks that the particular fraud which we're dealing with here was a serious issue, and they expected senior people within the organisation to ensure that they had policies and procedures for countering the risk that the firm might be used to further financial crime, including APP fraud and other payment services fraud, and requiring them to have adequate measures being in place to address APP fraud and other payment services fraud. I'm reading from the second page. And February 18, we then have the consultation by the Payment Services Regulator in relation to their model, and the code was then itself issued in 2019. Now, I'm going to take this out of turn for reasons which will become apparent in due course, because Mr. Brigton's evidence was that one part of this code was simply a distillation of what he considered was, in his experience, good industry practice already as at March 18. So that's why I'm taking it out of turn. not for the fact that we say the code applies to us or provides us with any redress. The code itself is at page 81. And the text, the overarching provisions are stated at 81, and it's made clear that the code should be read in light of and subject to applicable law and regulation, and nothing in this code should prevent any firm exercising its discretion, of course, to make a payment to a customer. We then have the definitions and scope, pages 82 and 83, and over to 84, and you'll see the exclusion within the scope of DS21 of anything other than transfers between sterling denominated UK domicile accounts and of course payments before the coming into force of the code. And the reason for that is because the code only works through an allocation and a sharing between sending and receiving banks. That will obviously have complications if it's associated with banks abroad. There's then the sort of general expectations section in terms of the firm, but the key part is the standards section over page 86 SF. So standards for firms, obviously that's shorthand for, and you can see the headline is SF1. Sending firms should take reasonable steps to protect their customers, and then they go into detection, prevention, response, etc. And the code there, given the evidence of Mr. Brigton, was then substantially replicated in our pleading. And then we have the response section, which is an important point to note over page 88, which is not dissimilar to what's been described as the quid square duty, which is that where a firm has sufficient concern that a payment may be an APP scam, it should take appropriate action to delay the payment while it investigates. In fact, it might be said that that's pretty much the same formulation. Now, of course, it also contains details about the payment journey involving the receiving firm, reimbursement cost of following scam, and allocation, and lots of other things, which I'm not going to go into. And the next port of call for my note was then to take us to the Brigton Report, which is at behind tab 5, page 142. I emphasise, as I did in the court below, not the finished article, just simply an indication to the court of why we consider we have real prospects of persuading a trial judge that the standards which we contended for were due and owing. And you'll see that Mr. Brigton sets out his experience at page 144, which you might want to briefly cast your eye over.
Can I just ask this, just before you say that the Brigton Report is to show that you had a reasonably arguable case on
showing that the standards that we pleaded and relied on were current banking practice, generally recognised standards of banks at the time in terms of the things they should be doing to take reasonable steps.
But the application to strike out was on the basis that there was no duty.
And I'm going to come on to this point as one of my... So what we say is that current banking practice goes both to duty and standards. Because when a customer contracts with a bank in relation to a payment service, unless there's anything to the contrary, they do so on the basis of the customary banking practice in relation to that particular transaction at the time. And we get that from title. So I'll come on to that point shortly. So yes, it's important to understand that it's absolutely our case. This doesn't just go to standards, it goes to duty as well. It's a recognition by the industry that they should be taking reasonable steps to prevent the fraud in question. That's the real headline point. And of course, we're a stranger to the industry, so what do? when we're seeking to make that out, we don't have access to the bank's own internal records. We glean what we can from what we're told, and we go to an expert, and we see what the expert has to say. And what the expert has to say is thankfully pretty concise. The body of it starts really at page 5.5. And the key passage really for present purposes is probably 5.5 and 5.6.
Should we read those to ourselves?
Yes, please. I mean, you could probably read that through to 5. Well, yeah. Quickly skim through until you decide that.
Okay.
There aren't many pages here. I think it's important to read them up to probably page 15. But, you may feel that you get enough in the first few paragraphs. The absolutely key point is in 5.6, and the point about distillation of good industry practice. You can see from 5.8 onwards, he then talks about the unusual features of the transactions here. In fact, he describes them in 5.9 as highly unusual, which I don't think is an understatement. Overstatement.
Where was her account held? Was it held at the Westbury-on-Trim branch? Or?
Yeah. So
the broad. Excuse me, Mr. Sims, but my knowledge of Barclays banks in Bristol is not great. But
so just to help you,
Broadmead is presumably somewhere in the
to help you,
centre of
the
town.
first place they go to is Thornbury, 10 miles away, not the local branch.
And where is Broadmead in the
Broadmead's
centre of
about
Bristol?
Broadmead's about 3 miles away from their home, and then so that was the second branch they visited, and that's when they made the first transaction, because their first visit to Thornbury was abortive because their systems were down apparently.
Yeah.
They then went to Broadmead, which again is not their local branch, and then the third one they went to the local branch.
Yeah.
So 3 different locations.
Okay.
Now you'll see that so far as the question of course, that would be all up for grabs at trial as to whether or not the transaction was sufficiently unusual to trigger alerts, etc. But we thought for a summary judgment application, we anticipated that would be sufficient, subject to the point about, of course, the court being satisfied that it goes to both the question of duties and standards. Now, there was one further document I just wanted to draw your attention to, was the ID and V tool, which is quite hard to see in the bundle that you've currently got. And we emailed in an additional blown up version. I don't know if that's found its way through to you or not, but
What page?
It's the supplemental bundle 210.
210.
So that's where it's. In fact, I think it starts at 210. So this is an internal document of the bank, and you can see that the first part of the process flow, which is identified on page 211, is to look at the value of the transaction, which obviously has resonance for how they are required to approach matters from a money laundering perspective. And you look at, in order to go to the next spots, what the value of the transaction is. There's a certain threshold set out there. And then over the page, we have another box at 212, which is the key box for present purposes, just to draw your attention to, which is if the transaction is 10,000 or more, make the customer aware of scams before proceeding with the transaction. Record conversations on Notepad if suspicious. Now, it's the blue box underneath that, which is a bit challenging on the eye. I've got, if it hasn't found its way through to you, some blown up versions of that.
We had, well, speaking for myself, I haven't got it. I don't think even.
It's
Do you really know who you are paying?
Shall I? Yeah. Shall I?
Payment request come unexpectedly. There we are. Look at that.
Shall I hand it up?
It's like an eye test, this.
If shall I put my mask?
I can only read it by getting so close.
I think actually it's easier electronically. That's probably why. My Lord Justice Birss is ahead of you. He's probably put the magnifying glass on.
Always knew there's a reason for bringing your computer into court. Thanks very much. Oh, that's much better, yes.
The first box was in fact referred to by the judge in his judgment. I think he faithfully quoted the first box, but I don't think we necessarily got all the additional customer as prompts as well. You may just want to read that to yourself.
Yeah.
So obviously there's a dispute of fact as regards whether or not those were given or not. Philipp say they weren't, and that's not for today. But that's to lose sight of the reason why we consider this document is of relevance. It's not decisive to the question of duty, because it recognises that the bank itself recognising the need to take steps in relation to this particular fraud and had effectively knitted in as part of its systems and processes. A point which I did note, and which I think is briefly alluded to in the judgment but not really followed through, is there seems to be additional references to other documents of relevance, like you'll see right at the bottom of the blue box, please refer to KIT or your quick reference guide for further information. We haven't had disclosure of that yet, so we don't know what that says. A document I'll come on to in a few moments' time would appear to suggest, as I submitted, it may have some relevance, but that's for later on down the line, I suspect. So, now
well, the position was that, as the judge recognises, that the banks, as I understand it, the two ladies at the bank who had dealt with Mrs. Philipp both said that they had read to her, at least one of them said that.
I think one of them said she would have done.
That she would have done, which is, yeah.
And one said she did.
One said she did.
There's all sorts of problems with their forensic problems with their notes, which
Mrs. Philipp has no recollection of that being.
She says it. She positively says they weren't said. And I mean, there's some problems with the notes. So, just to take one example, the Philipps, bless them, are unsophisticated people. They don't have a smartphone. They've got an old-fashioned mobile. Yet in the bank's notes, it suggested that they read something from one of their mobile phones in relation to the details of the transaction and the purpose of it. Just couldn't have happened. So there are small forensic points like that which we refer to show that we're not here to assess who's likely to come out on top on that. It's just kind of irrelevant for today's purposes. But substantial grounds of believing that she wasn't provided with those warnings. And she says in the reply, or there's a statement of truth in the reply, that she would have been shocked and visibly so in relation to the police don't actually ask you to.
Well, that's the point, isn't it? I mean, the critical point is that is the statement that the police would never ask you to, or it's put now. The bank or police would never ask you to transfer money to another account or safe account, and that's the essence of the warning that's given in relation to these APP.
And obviously, there are live questions about causation and all those sorts of things.
Yeah.
But the judge rightly concluded he couldn't get into that for summary purpose. So we come back to the key question of duty. Now, I accept that it may well be if we march to trial with just simply the idea veto, we might be on shaky ground for reasons I think which were identified by the Court of Appeal in a case called Morley, which my Lord Justice Birss was involved in, because in those circumstances, it's said against us, well, what the bank does isn't necessarily decisive in this context. You have to look at the recognition across the industry as a whole. So that's accepted by us. But as a summary judgment level, when you're looking prospectively what might be at trial, we refer to the Architects Wine case in support of this proposition. Question of what the bank's own current practices are likely to be informative of whether or not there's a generally recognised duty. Now, there are just two further documents I wanted to knit in, which weren't in the court below, but have been introduced by the intervener through the intervener bundle, and it's agreed that we can refer to for the purposes of our appeal. The first is a publicly available standard, which was not picked up on by us and was not referred to the judge in fairness to him, but we say strongly supports what Mr. Brigton was saying so far as the state of the industry practice at the time.
Yeah.
It may well be we don't need to go there in detail, and I don't want to steal Mr. McElroy's thunder, but if we go to the intervener bundle,
Page
174, and you can see that in fact by October 2017 there was a publicly available standard concerning protecting customers from financial harm as a result of fraud or financial abuse generally. And that, if you turn to the forward at page 177, was a standard sponsored by NatWest, but which was developed, facilitated by BSI Standards Limited, published under licence, and it came into effect on the 31st of October 2017. And you can see that Barclays are identified first on the list as a member of the steering group. And you can see that it's emphasised in this document it's not to be regarded as a British standard, but instead a code of practice, which takes the form of recommendations and guidance. Introduction at page 179, you can see the identification of what financial harm is, and then the purpose of the PAS being to help organisations protect customers from financial harm. That's the wording under the nice diagram at figure 1. And then you see the scope is then sort of repeated in section 1 at page 180. I'm going to quickly say so, but taking this quite quickly, you can see at page 181, you see a definition of authorised transaction under 2.1.3. If you briefly read that to yourselves. And then also 2.1.10, financial harm definition, which is simply because that's a phrase used later in the document, and then also 2.1.11. And then finally, 2.1.23, which is over the page 183. I'm then going to just simply invite you to note the organisational principles, culture and strategy of 184, section 3, the service planning and design of 186, talks about training, etc. And the key part is section 5, systems and tools for prevention and detection of fraud and financial abuse. And I invite you to read 5.1. Organisations should ensure that all systems are developed using technologies and methodologies that are effective in the prevention of fraud and financial abuse through authorised and non-authorised payments, thereby minimising the risk of financial harm to customers. And then there are various headings in relation to that. 5.2, prevention of fraud and financial abuse, and then they set out the organisation should ensure that systems and controls to prevent known fraud and financial abuse are in place across all channels and products, including in branch, etc. We then have obviously the various checks, which include things which you typically expect to see in terms of ID, account security, also enhanced security, transactional authentication, confirmation of payee, etc. But then at 5.3, detection of fraud and financial abuse, 5.3.1, this is a passage quoted by Mr. Green in his witness statement. The organisation should have measures in place across all payment channels and products identified in 5.2.1 to detect suspicious transactions or activities that might indicate fraud or financial abuse. So in other words, including authorised push payment fraud. And we then have examples of suspicious activity on customer accounts can include A, multiple checkbooks, B, sudden increased spending, C, transfers to other accounts, D, multiple password attempts, E, logins from new devices, multiple geographical locations, F, sudden changes in the operation of the account, G, a withdrawal or payment for a large amount, H, a payment or series of payments to a new payee, I, financial activity that matches a known method of fraud or financial abuse. Any suspicious transaction should be flagged on the system and the appropriate member of staff notified, and there's an escalation procedure involving escalation up to more senior staff depending on what's observed. One can go on and on, but there's, for example, then also section 8, taking action to prevent or reduce financial harm, which is just worth briefly noting. After 7, identification of vulnerable customers. We then have 8, action to prevent or reduce financial harm, risk assessments, and then remedial action. And at 8.3.1, note the organisation whose customer is the victim of financial harm should take responsibility for the resolution of the claim and see it through to its conclusion. Organisations whose customer is the suspected perpetrator of fraud or financial abuse should collaborate with the victim's bank to minimise financial harm to the victim, prevent any further losses, take necessary steps to recover funds, etc. Now, you'll note within 8.2.3, urgent threat of financial harm, that there is in place, and was in place by this time, an ability to call the police, actually into branch, under what was known as the banking protocol. This is something which we'd heard reference to. Still haven't seen a copy of the document, but in a moment, I would submit, may become relevant in due course. And you'll see that the banking protocol, in other words, the ability to call the police if there's concern that someone is about to become a victim of fraud, is identified and described in footnote 2 at page 202. And there was number of references in that document which make clear that so far as the industry is concerned, once the payment transaction has been given, the industry doesn't wash their hands of the situation if there is a reasonable prospect of helping the customer to recover the funds. It's viewed as part of the reasonable industry obligations to take reasonable steps to do what they can to assist. Unsurprising, we would respectfully submit. And you'll note that in footnote 2, page 202, sorry, I've skipped too quickly myself. The section where there's the reference to the banking protocol, if you go up a little higher, If a customer does display any indications that they're distress or concern, take the customer to a quiet area and call the police. Now that's not far removed from exactly what we were saying in our pleading, where there's generally recognised standards in relation to business and custom. Albeit we also drew parallels with the practices in place where the bank is on notice of duress and undue influence. We'll come back to that point in due course. But the simple point here is that this is all going on at the time. Now, there was one other document I just briefly wanted to refer to in the context of evidence about the banking protocol and what it might, and the industry standards in relation to detection and prevention. It's contained somewhat unconventionally within an ombudsman decision, but it's the only place I've been able to find reference to any detail of it. So that's where I take you to. And it's an ombudsman decision at page 228.
Of the same bundle?
Same bundle. In your own time, you might want to just briefly read through it in any event, because it gives a good example of how, unfortunately, the type of impersonation scam which the Phillips intelligent people fell victim to have plagued other people as well.
Speaking for myself, I've read the other one because that was referred to in somebody's skeleton.
It was referred to in Mr. McElroy's skeleton.
Well, in which case,
I read the one that starts at 235.
I'm grateful. The reason why I wanted to take you to 228
Yeah.
was really for the passage under the heading the banking protocol, but to get the context you might just want to read the first few pages so that you don't die straight in. It's a matter for you. You see some very similar features between this and Philip's case. So you'll see it's March 18, which is when this particular incident occurred. You'll see the approach taken by the Ombudsman, which, with our respectful submission, was impeccable in terms of the reasoning approach. But the key reason why we wanted to take you to this was under the heading banking protocol, for an indication that as at March 2018, not only is the banking protocol in place, but as recorded by the Ombudsman in broad terms, according to UK Finance's toolkit for PSP. So that's UK Finance, of course, is the industry body for financial services firms. Toolkit for PSPs. Financial businesses commit to look out for any unusual or out of character withdrawals and to implement the banking protocol procedure when such transactions are identified. So that's if this is correct, that the own industry toolkit is indicating that that's what they should be doing. My hunch is that the bank's own internal toolkit probably says a similar thing. Now,
and what he decides is that effectively reading the script is not sufficient
on the facts of that case.
on the facts of that case.
Yeah, because part of the problem with these frauds, and the reason why they're so nasty, is they get the victims to believe that they have to run a cover story in order to keep themselves safe and also to stop the fraud balloon going up. Because they're thinking, I need to obey what these people are doing. In fact, I think the Phillips, not only were the Phillips told that this was something that they needed to keep their accounts safe, but it was it was in accordance with their public duty to do so. They were helping to prevent fraud, a wider spread fraud. Dr. Philipp, who worked as a public health consultant until his retirement, was a publicly minded person, thought he was doing the right thing, sadly. And in relation to all of this, we then end up with a situation where they are told, well, you need to run a cover story if you ask certain questions in order to try and stop the fraud happening. And that becomes complicated. I accept it becomes complicated as to how that then is untangled as a matter of causation. But here, obviously, they're saying, well, the bank should probe into that cover story, to not simply accept the cover story. And what Mr. Brigton says is, well, hang on a second, if someone comes up with their husband into the branch and says, I've had previous dealings with Petroleum and I'm transferring this money out of my wife's account out to UAE. So well, why aren't you paying it yourself directly? And that's the obvious question which Mr. Brigton says would immediately come to mind, which
a huge amount of money going into an account which had only previously had £10,000 or so.
I think I got to 7 flags. I think at Para 108, I think the judge identified them as 5. I think he combined a few of them, perhaps as part of that analysis. It probably doesn't matter. I think he missed off foreign payments as one of the red flags, but
yeah,
there were lots of flags on this one. It was an extreme case, frankly. In terms of, you don't really even need to have a sort of sophisticated customer analytics program and algorithm to work this one out. But as it happens, no doubt the banks do have that. So that's the position we find ourselves now. So far as the position in relation to, I wasn't going to take you to the underlying contemporaneous notes because the judge has dealt with that in quite a lot of detail in the judgment, and I don't think it's particularly, unless there's any particular feature you wanted me to take you to, I'm just simply going to summarise that the judge has substantially accurately summarised them in his judgment from paragraphs 27 to 71. And you can probably summarise it by saying it's a sophisticated APP scam involving phishing, spoofing, the sort of technical phrases, but all sorts of deception going on with telephones and intercepting numbers. So telling the Phillips to call them the number for the bank on the back of their card and then intercepting that so they're not speaking to the bank but actually the fraudsters, all those sorts of things. Cover story social engineering, which resulted in these two intelligent people being conned into thinking that they were working with the FCA and the NTA, and as I said, had a duty to transfer first 400,000 on one location, then 300,000 the next day. So the transactions were ultimately processed according to the evidence on the 12th and 13th of March to these so-called FCA safe accounts in the UAE. Now, of course, it's common ground that those payments did not reflect their true intention. They were not, because they weren't payments to a safe account, they were payments to the fraudsters who haven't been identified or brought to justice. And really the key point so far as the facts in this case are concerned is that so far as the question in relation to the evidence as to what was adduced in the court below, the only other sort of factual point we wanted to identify was we'd been asking for the SWIFT documents, SWIFT transaction documents from the banks in advance of pleading out our case because we wanted to know precise dates when they were actually left, because on the 16th of March there was a tip-off by someone called DC Billen phoning the bank's fraud officer saying that Mrs. Phillips' account was compromised and made a reference to Lambert Petroleum, which of course was the account which there had been a payment to on the 12th. And we were interested in that and understanding exactly when it might have been possible to recover the monies, because in fact the bank, on the face of it, looks like it didn't take steps to try and recover the monies until about May. But that probably all goes to the question of causation rather than duties. This was, of course, an international transfer, I should say. It's not a same-day payment type process like the CHAPS payment system. CF title paragraph 53, which we'll come on to in a few moments' time. And there was no particular time frame which the bank promised in relation to this particular transaction. The bank did issue a letter, I think, giving an indication the transfer might take up to 7 days to get to the beneficiary. I think Mr. Brigton's evidence was that he probably thought it would be quicker, but that was one part of the evidence which the judge seems to have taken into account. The reason why I mention this is because this is not a case where the bank can point to being in breach of contract simply because it delays payment. Certainly not on the basis of the transaction documents which it relies on. That was the final point I wanted to really deal with in terms of the facts, was the contractual terms point. The bank relied on contractual terms and conditions. Mrs. Philipp was unaware of their application on her pleading case as verified by a statement of truth, and put the bank to proof as to those and as to their incorporation. In our reply, see paragraph 8. At paragraph 32 of the evidence in support of the summary judgment application, there was simply a bare assertion by Ms. Stoddard that the terms and conditions applied to the account without explaining how or why. They were exhibited, and if your lordships want a reference for them,
Did the judge make any findings about this?
he did as a reinforcing point. He referred to them at paragraph 89 and also paragraph 153 little 1 last sentence.
89. Yeah, 89, and what was the other paragraph?
153. Roman numeral 1, as a reinforcing point, last sentence.
Yeah.
I don't detect my learned friend on this appeal is clinging on to that point particularly firmly, but it is there. Now, the first point we want to make in this respect is just simply to invite you to note that somewhat startlingly, my learned friend in his skeleton argument is suggesting we bore the burden of proof on it. We had no duty to assert any positive case beyond the non-admission. It was for him to adduce evidence as to incorporation of terms and conditions. They didn't do so. Of course, we would readily accept that if they adduced evidence to show that they were sufficiently brought to the attention of Mrs. Philipp, then they may well have been incorporated. But in any event, as a second point, the passage which the judge quoted from in 89 is a long way away from a contracting out, if I can put it that way, of any responsibility or duty in relation to APP fraud. Simply says, someone persuades you to pay them money and you feel you've been cheated or should not agree to pay them, we are unlikely to be able to refund the money. That's a long way away from being sufficient to...
Well, that goes to remedy anyway.
Yeah.
Exactly. It's nothing to the point. And more importantly, if in fact these terms and conditions are incorporated into the contract in any event, unsurprisingly, within the terms and conditions, they contain clauses which do make clear that if the bank reasonably thinks that a payment in or the out account is connected to fraud, they don't have to follow the instructions. And that's, if you want the reference to that, that's at page 59 in the supplemental one. You can read the section, it's section 6 of the terms. There's a reference to stopping payment tools, and then when do we not have to follow your instructions, and it's the fourth bullet point down, I think. And there's also other references to you don't have to carry out a transaction if it might break a law, regulation, or code. Well, query whether or not the passcode here would be such a code, etc., etc. I mean, there are all sorts of points there. But the short point is that we would submit before your lordships that we're not really here into terms and conditions territory in terms of governing the position. The position really
Well, the trouble
lies
is, once you get into terms and conditions territory, you're into trial territory. Simple as that. I mean, you only got to look at what the pleadings are. I mean, they plead that that she was in what's described as gross negligence.
Yeah.
And therefore, a sufficiently serious breach of the terms and conditions that there's no right of recovery. And unsurprisingly, one of your pleas in response to that is, if you're right about that, see the Unfair Contract Terms Act.
Yeah. So, I mean,
And that's all exactly the sort of territory it is for a trial judge to determine.
your lordships all seem to be on top of the salient points, and the case, and I was probably, unless there's anything else, I was mindful of the clock, going to move on to my second heading. Your lordships, unless there's any particular points arising out of the statements of case or the application evidence in the court below, I think you have my point already about that, about the state of the evidence in the court below and the lack of evidence on the bank side. And you'll note that there was a debate before the judge below as regards whether or not, in actual fact, there was an admission sufficient on the bank's pleading for the purposes of our case, but ultimately the judge didn't approach it in that way, and we don't criticise him for not doing so, for doing it on substance rather than the pleading technicalities. There was one minor forensic point I just wanted you to note, that there seems to be some hesitancy on the bank side of their pleading to recognise in relation to the formulation in common law of the duty to exercise reasonable skill and care in and about the payment service is the formulation. If you look at paragraph 4A, little 2 of the defence, they use the word in but not about. Maybe a minor forensic point, but it's maybe an indicator to the sorts of arguments my own friend now wants to seek to deploy in response to our appeal. So heading 2, propositions. And the first point I wanted to address was the point which my Lord Justice Coulson identified, which is why is current industry practice relevant to both duty and standards. And we submit that in answering the question of what is required of a bank in order to carry out the service in question, I think I've made this point already, but just simply to repeat it, with reasonable skill and care. In the absence of express terms to the contrary, the customer is ordinarily taken to contract with a banker on the basis of the current banking practice. That's the simple point. In relation to the performance by the banker of that particular payment service, at this stage I wanted to take you into the authorities, and the first one on the list is in fact the Court of Appeal Untitled Energy. If you give me a few moments, I've discovered that my alert settings on my computer need to be adjusted somewhat. I need to get it back on because I'm trying to use the authorities on in the electronic format if I can. It's tab 28. E-bundle reference for it is, if you're using the Regulator 1001. Now,
Sorry. The authority was which?
Tidal Energy, tab 28. Hope I've got that okay. It's decision of the Court of Appeal of Lord Dyson, Master Rolls, Tomlinson and Floyd LBJ, and it's a somewhat controversial decision because it was a split decision, went up to the Supreme Court on a commission, but was then settled because some took the view that the approach to interpretation was an unusual one in terms of the way that the majority of the Court of Appeal approached it. But for present purposes, the factual circumstances of the case you'll see were it related to a chap's payment, and the claimant agreed that the payment was to be made. The holding was, if you look at holding number 1, Lord Justice Floyd dissented, that the claimant had agreed that the payments to be made in accordance with the usual banking practice that govern CHAPS transactions. And then, because of the short timescale, which is the hallmark of the CHAPS case, and the evidence, the industry evidence provided by the bank in the court below, the court was satisfied that the identifiers which were required for the bank to check for the purpose of the CHAPS transactions were three identifiers, not four, the fourth being the actual account name. But the passages which I just wanted to highlight for present purposes, so far as the point I wanted to just draw out, so far as the question of the principles, the transcript of the report starts with the dissent of Lord Justice Floyd, and then you see the majority judgments of Lord Justice Tomlinson and Dyson follow. So Lord Justice Tomlinson, who's in the majority, his judgment starts at page 1179, paragraph 39. I was going to start with the judgment of Lord Dyson, Master Rolls, at paragraph 51. And you'll note he refers to certain features of the CHAPS electronic banking scheme in paragraph 53. And then very influential in terms of the actual outcome of the appeal was then certain evidence tendered by the bank's witness, Mr. Johnson. You'll see that at paragraph 54 and 55, which is quoted. And the evidence of the bank was that because this is such a process that we need to process, if we have to do the checks in relation to the member names, and that's going to be economically impossible to do if we need to get this done within 1.5 hours, which is what we need to do in order to comply with the process. And then there's then further evidence from Mr. Johnson's regards other things they have to do in relation to CHAPS matters. And then at 56, in my view, the critical question in this case is whether the banking practice described by Mr. Johnson can be relied on in order to construe the transfer form. So what the approach was for the purposes of ascertaining the scope of the duty owed by the bank in this case, it went to both matters, both the standards and the scope of duty. And you can see that from the reasoning of Master Rolls, which runs through from 57, the key passage is 59. But if I invite you to read the passages in between, it's the stepping stones too, really. So what the sort of touchstone is really here in terms of where the case turns is the customer, in the absence of any contrary terms, being taken to contract by reference to the reasonable usage of bankers when instructing the bank. And that is why, my lords, I say that the evidence of current industry practice as regards what banks do when they're instructed to make a payment transfer goes to both the question of duty and breach, for the same reasons as identified by the Master Rolls in this case. I should draw your attention to the other concurring judgment from Lord Justice Tomlinson as well. And you can see some equivocation on his part as regards what he viewed as being the right outcome of the case. I think Lord Dyson has written extrajudicially as to the sequence of events in terms of the judgments in this case. But so far as the key points so far as what sway him are really from paragraphs 48 to 49. So, my lords, what we take from that is that evidence of what the current banking practice goes to both the scope of duty and whether it's been the standards and whether it's been complied with, and of course, expert evidence of what the current banking practice is a classic area where expert evidence may be produced. Going back to cases, well, such as Mr. Justice Oliver and Midland Bank Trust. Now, I recognise it may be said against me in relation to this case that this was in fact a fraud case, and it doesn't look like the points that you're running, Mr. Sims, were running this case. The points you're raising as good ones. Why wasn't the point raised in this case as regards a more general duty to protect against fraud? And of course, I cannot know for certain the reasons why the point wasn't taken in title, but one presumes that the customer just took the mandate point rather than the more wider point, because they didn't have evidence to show that the bank knew facts which were out of the ordinary and which gave rise to the trigger of a potential duty owing in relation to this particular transaction. And if you think about tax payments, then that context may also militate against them thinking they actually would succeed on a case involving a breach of duty or otherwise. A further point I wanted to note in this context, so far as the question of industry practice going to the question of duty, is that if you look at Quinscare itself, Mr. Justice Steen was influenced by the evidence before him of the expert banker, the banker who gave evidence before him as to what he would do and what he recognised should be done. And if we go briefly to the passage in Quinscare, which I think is frequently cited, is tab 3 on the authorities bundle, and it's the passage which quotes our skeleton, paragraph 36. At 376H is the passage I wanted to draw your attention to in particular. You can see after the reference to Lipkin and Gorman, Mrs. Justice Dean, as he then said, having rationalised where he thought that the landing point should be, he said, after referring to the external standard being an ordinary prudent banker, that in my judgment is not too high a standard. Indeed, the evidence of Mr. Redhead, most experienced bankers show that the principle which I've stated is the very criterion usually applied by bankers. Well, if I may say so, that was quite likely to be so, because if the test really is what a reasonable banker would do, whether they had reasonable grounds for believing that there was something out of the usual here which indicated signs of misappropriation of funds, and of course you would expect the two to match. A judge may approach this question from two different ends of the telescope. A judge may approach it by reference to principle, as to whether or not they consider something is reasonable or not, as well as simply what current banking practice does. And of course you see, I think in actually one of the judgments in Untitled, I probably should have drawn it to your Lordship's attention, but Lord Justice Tomlinson and it's generally recognised that the court does reserve to itself, even in cases of cases looking at reasonable industry practice, whether or not actually the court is going to accept that not as being reasonable. There's that additional layer, if I can put it that way, which the court reserves to itself. So it's possible to approach these from both ends. But the short point is that we submitted to the judge below that, look, here in the precise case where everyone refers back to as a formulation of duties where there's risk of fraud, the judge himself was influenced by the evidence of the experienced banker before him. And on a summary judgment basis, that's not something that should be lightly discarded. So the second point I wanted to then make was to do with the bank's evidence as to its own practice. And of course, the only bit we got visibility of was the ID&V document. But if I can now refer to the Architects of Wine case, which...
this is when you say the own practice, you mean that's the illegible tool?
The illegible tool, yeah, that's the only thing we have. So there's a lot, I'm sure there's a lot more to it than that.
Yeah.
But the visibility we have in that respect is obviously limited right now. The bank is required to give disclosure until later on in the process.
So Architects of Wine is the case you sent us yesterday?
It is, yeah. I've got spare copies if, for whatever reason, it didn't find its way through to any of the audiences.
I've got it electronically, but since I haven't got my laptop, I shall take a copy.
Yeah.
Thank you very much.
There's two just in case. Now, this is a judgment of the Court of Appeal in 2007. The reason why I was taken to it was because there's a passage quoted of Lord Justice Diplock in Mafani in Lipkin Gorman, which caught my eye and which is also picked up on in this case. Now, this case, of course, was to do with checks, and you'll see from the head note that as a protection, the bank against an action for conversion against a bank, there's a qualified duty under Section 4, which is basically one of reasonable skill and care or negligence. So if they discharge that duty, they're not liable for conversion. If you read just the head note briefly after that, you can see that summary judgment had been granted against the bank because the checks were in fact made out to a company, a Cayman Island company, not the UK company, but that wasn't identified when they were processed. And so there was a question of whether or not there was a sufficient match between the names and purposes of assessing negligence or not. And the judge in the court below concluded that there should be summary judgment granted against the bank, and the Court of Appeal said no. And the reason why they said no was because there was relevant evidence of the current practice of bankers, and the court wasn't bound by that evidence, but it'd be hesitant to reject it. And the key passages start at paragraph 1 of the judgment of the Lord Justice Ricks, and it's probably just easiest for you to read through from paragraphs 1 to 12 to yourselves, but the key passage so far as evidence of the practice of bankers as part of this submission is paragraph 5. And it's a quotation from Mafani.
Sorry, 5, did you say?
Yes,
It's really 4, isn't it?
4, isn't it?
It's have I got the wrong paragraph?
4. 4 is the citation from
5
the 2
is-
citations.
Yeah. Four is the part quoted in Lipkin Gorman.
What facts ought to be known to the
Yeah,
bank?
and it's the concluding in paragraph in 4.
Yeah.
But also, the point I wanted to draw out here was that in 5, the evidence of the practice of bankers is the point we were just discussing a few moments ago, that's influential to the court as regards whether or not there's been negligence in any particular case, because it's relevant to the question of what is the current banking practice. So you can see the phrase, it seems a reasonable inference that what the defendants did in the present case was in accordance with current banking practice. I agree the other passages are also relevant for this case, but that was the particular point I was seeking to knit in. That evidentially is not irrelevant to what the current banking practice is. I can't put it any higher than that. I think.
So what the bank did is relevant to what is current banking practice generally.
Exactly.
It's as simple as that, isn't it?
It's as simple as that.
Okay.
It may be I didn't need to cite authority for that proposition, but there's
Not sure we need 12 paragraphs to deduce that.
no. There's a useful passage, as you've identified in paragraph 4 as well. The passages which have just been referred to. And of course, there's a warning from this case as well about proceeding some error. Thirdly, the third point I wanted to make was that, of course, what is precisely required by the banks, how quickly they act, how long they delay, etc., will depend on the type of payment instruction and, of course, any particular terms of the contract they may seek to include in any arrangement. But not making a payment or only doing so after a delay does not mean the bank is acting outside the mandate. And that should be uncontroversial, but if you want the reference for it, it's Paget 2251. It may be helpful just to go to Paget now, just to look at the point.
And Paget is
Tab 45. It starts at the relevant passage starts at 2251, saying the obvious proposition the bank is under a duty to obey the customer's mandate. And then it says the bank acts outside the mandate, e.g. transmitting a payment message to the wrong bank, to the wrong payee or the wrong amount. Then it's obviously strictly liable. That was the sort of the point which was run Untitled. And then over the page, the doctrine of strict compliance, which applies to documentary credit transactions, has been held to apply, not to apply to a customer's instruction to transfer funds. Where a payment is not made at all or is made only after a delay, the originator's bank does not act outside its mandate. In such cases, the originator's bank will only be liable for the customer's consequential loss where this is caused by its own negligence or that of its employees or agents. So, we would respectfully submit that delaying and refraining from making a payment because of concern about fraud is not a breach of mandate. And the judge erred in thinking there was some form of unreasonable emasculation of any primary duty in paragraph 158 of his judgment, where he seems to conclude that was so. Fourth, this point is trite, but it's worth just simply re-emphasising that, and you can see it replicated in the passages in Paget 22.52 and onwards, that if we look closely at the source of the duty here, it's replicated in section 13 and also common law. When a customer of a bank instructs the bank to provide a payment service, they will carry out that service with reasonable skill and care. common law formulation is in and about executing the customer's orders. And there are various cases cited as authority for that proposition I don't need to go into. But the phrase in and about, as interpreted in the common law, or the phrase a term implied by section 13, we submit, contemplates anything which a reasonable banker would consider appropriate to consider when receiving the payment instruction and dealing with it, having regard to all the circumstances and facts. And indeed, the formulation, I think, which my Lord Justice Coulson identified at the end of paragraph 4 in Architects White's from the judgment law, Justice Ditbucking finally makes that point. We would submit where there's a reasonable, realistic chance of preventing a loss due to facts which come to the attention of the bank before funds are cleared to the beneficiary receiving a loan. Then, like the CRM code, the duty should extend accordingly, not simply to just up to when the payment transaction is executed. But the main focus of our submission for today's purposes is on the facts and circumstances which lead up to the payment, which we respectfully submit are more than sufficient to trigger a duty to press pause, or arguably so for summary judgment purposes. Fifth, of course,
Will you repeat that submission? Your fourth proposition is that there's a duty of care in and about
the services provided.
Execute.
Yeah.
Well, you pleaded that at paragraph 56 of your points of claim and particulars of claim, and it's admitted at paragraph 40.
Exactly, and so
47.
My submission, which follows on
This
from
is not a case where there's no duty.
exactly. So the duty is recognised.
Well,
And
it's not in dispute.
No, you're quite right. Fifth, of course, we accept.
Well, your point about, as I understand it, why you emphasise the in or about, is that those words are wide enough to encompass not just execution per se, but also, as you put it, whatever a reasonable banker would consider appropriate in the circumstances,
Exactly.
which would include the declining to execute because of concerns about protecting the customer.
Exactly. And it may include, depending on the current banking industry practice, taking steps to try and recover. That's obviously fact sensitive. You've just got the point. I'll move on. Fifthly, in relation to the potential conflict with mandate, I think I've already made this point, but the law resolves that potential conflict by the application of the reasonable banker or ordinary prudent banker test. That's the way that
Conflict between
the potential conflict between the customer saying I want this paid and the bank saying no, well we need to stop, because of course the bank may be sued by the customer saying I told you you should pay. And the resolution of that potential conflict is resolved by what would an ordinary reasonable banker do in those circumstances, which of course is a fact-sensitive exercise depending on the particular facts of any case. And I emphasise, again, this is our fifth point really, that
It's interesting that because that sentence in 22, in the first sentence of 2253, in a sense is quite puzzling when you look back at what's said at the top of the page about the doctrine of strict compliance not applying outside the context of documentary credits, because it might be said that if the duty in and about is, as you say, encompasses doing anything which a reasonable banker would consider appropriate, which would include if there was a flag of some kind, or they were put on an inquiry in some way, not making the payment, or at least delaying in making the payment, then in actual fact there is no conflict.
I think your lordship has hit the nail on the head. You've used the word actual conflict, and I think the phrase in Paget is more cautious, which is may, isn't it?
Yeah.
So it's contemplating a potential There's a tension between those. That's really what they're saying. There's a tension between those two.
I mean, it's difficult to see it in terms of conflict because it would never be an answer. I mean, if you take the classic Quinscare case, even if the bank is right as to the limitations, so the managing director, as it were, notionally turns up and says to the bank, pay £100,000 into my Cayman Islands account, please. But the bank is put on inquiry that he's acting in some fraudulent way and doesn't comply with that instruction. That would not be failing to comply with a mandate in terms of the way in which the duty to do so is qualified in 2251.
Absolutely. If you don't make the payment and you have reasonable grounds,
It's been breached by not making the payment.
exactly. There is no actual conflict. That's the headline. The point I wanted to emphasise is that because this is a sort of a drumbeat that my learned friend hits quite hard in his skeleton argument, which is well, this is all going to create all sorts of problems. We do thousands of transactions, millions of transactions, etc., etc. Well, we're not really asking for anything particularly extravagant here. This is unusual, out of the ordinary transactions, which a reasonable banker would press pause on. We're adopting their own standards as part of inherent in our case. This isn't a dramatic development of
But they're not chaps transactions either.
They're not chats transactions either.
So they're in-branch transactions for really quite unusually large sums of money in the circumstances of a particular customer.
Exactly.
I can't imagine that Barclays Bank at Westbury-on-Trim gets asked very often to make transfers of this size.
One would not expect so. Of course, we accept there may be other circumstances when the bank digs into it, which may be relevant. If it turns out, in fact,
But
that they didn't.
Interorum doesn't really get them anywhere,
No,
does it?
exactly. This isn't your this isn't going to cause the wheels to grind to a halt in the banking industry. The shrill tones of this being unduly onerous are just simply hollow, not supported by any evidence.
But in any event, I mean, assume that there may be something in that. That would be a matter of evidence.
Exactly. No, and the bank didn't put any evidence in the court below.
I can't help feeling that the words, a summary judgment application should not be a mini trial, which is inexorably towards this case.
Yeah.
On just looking at the points that were in issue.
The
50 odd
length
paragraphs.
of the witness statements.
Yeah, 50 odd paragraphs,
Well,
70 odd in response.
The documents that are before this court.
I can't. I think the case went on beyond a day from memory. I can't quite remember now. It was online. It one blurs into another. I'm afraid.
I mean, this point is quite a good example. You may go too far to say, well, this is a straightforward matter, and Mr. Goodall may well say, well, no, it isn't, and it does have ramifications, whatever. But none of that can be properly resolved on a summary judgment.
Well, exactly. Well, let's assuming, even I'm wrong, that this is a sort of novel development, and this isn't just a sort of a different factual scenario within an established category case. Well, all the policy factors there, evidence as regards whether or not actually it is going to cause problems to the banking industry. Well, I struggle to see how that would actually arise, but it needs evidence.
Well, it may be, but it would be not a matter for summary judgment.
I agree.
It's a trial.
My next heading then, I think, was I was just going to take you to what we say about the Quinscare duty.
Do you have a proposition for my laborious notes?
Yes, I do.
It's your sixth proposition.
It is. I agree with my lord.
Yeah, whatever you say, if it's my sixth, it's my sixth.
It is. We have decided. There's a majority of this court that says this is your sixth proposition.
Good. Okay.
And my pen is quivering with anticipation.
Well, here we go. The Quint's care duty has been hammered out in company cases where the director is ostensibly authorised, but in fact where they are or may be acting outside or without their actual authority of their principal and committing a fraud on them. But properly understood, it is simply an aspect of the general overarching duty of reasonable skill and care in the provision of payment services by the banks. That's the proposition. An aspect of the general overarching duty of reasonable skill and care in the provision of payment services by the banks. And for a recent endorsement of that proposition, we would draw your attention to the judgment of Lady Justice Rose, as you know was, in Nigeria and JP Morgan. And that is 9 tab 14.
Yes. Tab 14.
Yeah. Now, this was a case where there was a battle as to whether or not someone had effectively contractually excluded what's become known as the Quint's care duty, that could, as has already been identified, be traced back to the authority. You see that, according to Lady Justice Rose, paragraph 40, the electronic reference, if Honourable Justice Birss wants to indicate, if you want to use the navigator 433, should get you there. You can see that, having analysed the principles, she says the Quint's care duty is one aspect of a bank's overall duty to exercise reasonable care and skill in the service it provides. Of course, it, as classically stated, arises in the context of misappropriation by an agent on their principle. But it is properly understood simply an aspect of that duty, general duty. And I was then going to, and it may well be I get slapped down on this, take your wishes back to 1926. What I was wanting to do was just to make good the point that really what's recognised in Quint's care shouldn't really be called the Quint's care duty. There's nothing novel about it. It is born out of that point, that principle, in a particular factual, obviously, circumstance. And the reason why I wanted to go back to 1926 was because of the House of Lords decision in Hilton, Westminster Bank. And I was going to start in the Court of Appeal behind tab 9. Now, the reason why this case is quite interesting is because it's not a case involving a misappropriation by an agent on their company principle, but in fact is involving a mistake made by the customer. The facts are a little bit confusing to understand, but you may just want to briefly read the head note to familiarise yourself with the factual circumstances if you're not already familiar with them. But the short point really was to do with an error in terms of check numbers.
Yeah.
And so we can see that the customer sought to countermand a cheque but made a mistake when referring to the number of it. It was cheque number 285, not 283. And the question arose as to whether or not the bank was liable for processing both of the cheques and whether it ought to have made inquiries. The first instance judge concluded that the countermand was clear and unambiguous, and therefore the bank was not guilty of negligence. So in other words, because the wrong number was referred to, the case stopped there. And the Court of Appeal disagreed, made some statements of general principle which ultimately were not disagreed with by the House of Lords. But the House of Lords took a different approach than the Court of Appeal because of the view they took as the evidence. But looking at statements of general principle, we see, as marked up on the same page, the general principle stated by Lord Justice Banks in this context as being a duty to take reasonable care in carrying out for its customer's business. And it then goes on to deal with some of the facts of the case. And we see that what was influential to the Court of Appeal was some evidence as regards a telephone conversation, as regards the cheque and what was said about the cheque, which they interpreted as potentially putting the bank on notice as regards the mistake. And the manager was called, as well as the cashier, and you can see in the first column there's reference to the fact that the manager of the bank admitted in evidence that if he'd received the telephone call, he would have understood it in the way it was suggested would give rise to a concern as regards the mistake in question. And you'll see over the page, second column of page 359, near the top of the page, there's the marked passage. Now, if there is a duty, and I'll say a word about that in a moment, on the bank when they receive instructions with reference to payment, or which require confirmation to make inquiries, the opportunity to make inquiries and none were made. And then you see the disagreement with a judge in the court below at the bottom of that column, in taking too narrow a view of the case. And there's a discussion about how the judge dealt with the matter. And then at page 360, first column, there's the phrase, but there is another way of putting this case, which it seems to me clearly conclusive from the point of view of the plaintiff, which is, and he refers to the decision in Curtis of London City, and notes that in the course of giving judgment, the Lordships observed that that case wasn't a case for negligence, simply a case about the countermand. And he says it's a case of failure to comply with precise countermand. I think all the Lord Justices indicate that in their opinion, where a bank receives instructions with reference to the payment of a cheque, it may be that those instructions are not such that the bank is bound to act upon them without inquiry as to a countermand. Yet they may be such that the bank should not pay the cheque. And then he goes on to consider this aspect of it, which is a sort of wider negligence point. At the top of the page, second column, makes the sort of factual points against the bank.
It's the point that if the manager had gone away and looked at the cheques that had been honoured, he'd have found that the 283 had already been honoured in the past.
Exactly, and the taken with the evidence of the cashier's, the telephone call with the cashier, and the bank manager said, well, if I'd known about that, then, and that's where the case fell down in the House of Lords, because the House of Lords said, well, you were using the bank manager as a quasi-expert. What the bank manager said about what they would have done is not the point. The point is whether or not the cashier acted in accordance with ordinary banking practices. So that's where they fell down. I think it's an early illustration of the court's being critical of the judge stepping into the arena, because the evidence of the bank manager was elicited through a series of leading questions by the judge himself.
Mr. Justice Horridge, from recollection, was not one of the great legal intellects of the 1920s.
Well, but the important point here is really sort of just before the Warrington LJ starts his judgment. It says that grounds which I've endeavoured to indicate that this was a case in which the bank failed in their duty either because on the materials before them they were not satisfied when they ought to have been that there was a countermand, or because having regard to the information and instructions they'd received, it was obviously a case in which they should have made some inquiry before paying the cheque on presentation. So what this is talking about is really quite a simple point, which is that where an agent acts for their principal, if they're on notice that actually what going on here is not what their principal really wants, then there's a duty of care to look into that further. It's really as simple as that. Now, Lord Justice Warrington is similar formulations as regards the real question being reasonable skill and care. You can see that from the highlighted passage on that page, and conclusion that the appeal ought to be allowed. Similarly, over the page, Lord Justice Atkinson noted that...
No, Lord Justice Atkin.
Oh, sorry, Atkin. Lord Justice Atkin. Yeah, rather different.
Contrary to my Lord's views of Mr. Justice Horridge, might be regarded as a rather bigger name in these circumstances.
And one I shouldn't have got wrong, quite right. So, in relation to his judgment, he notes, and this is an important point, I think, the judgment that this court has delivered is likely to make, he says, I do not think that the judgment that this court has delivered is likely to make much difference in the burden that is thrown upon banks in relation to their customers. And he goes on then to emphasise the duty of the bank arising out of contract over the page to exercise reasonable skill and care in dealing with the communications which the customer sends them in relation to his banking business. And then he then refers to the evidence which was adduced and looks at reasonable skill and care test and how that's applied in the facts. Now, as I said, that the matter went further, and I'm sorry, because we went alphabetically, this one seems to have got separated off from. We now need to go for the House of Lords decision to tab 31, and
perfectly reasonable to put the authorities in alphabetical order rather than chronological.
On reflection, I thought perhaps they could have been grouped together. If you want the e-bundle reference, it's 1054.
31.
Yeah, tab 31. And ultimately, they concluded that the appeal should be allowed. You can see the holding that one certain item of identification was the number which the bank relied on, and the bank was not guilty of negligence, and the action failed. So they don't say anything to displace the statements of general principle made in the Court of Appeal, but you can see the judgment starts with Viscount Dunedin, Lord Dunedin, page 125, and you'll see that the reference to the evidence adduced by Mr. Justice Horridge, which I've just referred to at 126 in the first column. And then you can see this sort of the critical reasoning in terms of why the appeal should be allowed. At one time, I was at one time inclined to think that in as much as both the cashier and the manager knew that there was a stop and check, they ought to have made certain investigations, but I find they did so. They followed the ordinary practice. They looked at the ledger, and the ledger showed that no cheque in favour of Poe to come in. I think, therefore, that the view of the officials was correct, and the cheque presented being subsequent to the date of the stop instructions might be a duplicate cheque, and that they were bound to cash it. And sorry, so here we have Lord Atkinson rather than Lord Atkins follows. And there's a passage there as regards the sort of where the duty arises from.
It turns on its own facts in the end, doesn't it?
Exactly. So ultimately, it turns on its own facts. I don't think there's anything really that I need to go on beyond.
Does the House of Lords rather say anything at all about the duty?
Well,
I mean, they seem to have focused on the facts of the case and what's described as the most unfortunate intervention by the trial judge.
yeah, I mean, I don't think directly, though. I think in cases like Lipkin Gorman, for example, Viscount Dunedin, Lord Dunedin's observations are taken to support the proposition that what the agent is required to do is to look at the real intentions of their customer. I'll come on to that briefly when we look at Lipkin Gorman. Now, of course, the facts of that case are far removed. Banking practices are very different now than they were then. But what we say is that this case supports the general proposition that where the bank is put on inquiry as to facts which suggest that the instruction they've been given doesn't reflect the true or real intention of the customer, whatever it may say on its face, then the bank may be under duty to inquire. Of course, this case arose in the context of a mistake by the customer, but there's no reason to differentiate that principle from fraud. Both involve a duty to protect the customer from their own mistake. It's just that in the case of fraud, the mistake is induced by a third party. And we would submit that we see the same basic approach being taken in relation to fraud in the context of processing of cheques, which is, I think, Mark Farney as quoted later on in the Architects of Wine case, and of course the Lipkin Gorman. Now, if we move on to Selingor and Carrot Rubber, I suspect I can take these quite quickly because your lordships will be familiar with them. But 1968 is the decision of Mr. Justice Ungoed Thomas in Selingor, and that behind tab 22. The e-bundle reference is 701. And this was a case which involved the misuse of company monies by the directors.
Sorry, we're just about to look at Selingor. What do you say? What's the proposition you're getting from Selingor?
Firstly, that the approach taken to ascertaining the duty is simply the objective standard applicable to bankers. And secondly, that it's focused on their really intended instructions as opposed to simply being able to act on signatures misused to defeat their intentions. Wrapped up within those, there's probably a third point, which is a rejection of the notion that banking law is a separate body of law.
Rejection of
the proposition that banking law is a separate body of law.
Argued by 6 counsel who ended up either in the Court of Appeal or the House of Lords.
Yeah.
No, 7 actually.
Well, I have to say,
one of them, I think, Mr. Justice Bagnall only first instance, I think, but everybody else.
well, the law reports tell their stories.
Sort of
Tell their
cast
stories about career paths, don't they?
Of Chancery and banking lawyers, isn't it?
Yeah.
It also seems to have taken, as my lord pointed out before we began, it seems to have taken up most of 1968, which must have been, well, perhaps not most of it, but certainly the whole of the equivalent term to this one. Quite extraordinary length of trial.
Yeah.
All I would say is it's before proper case management.
So you're going to say it was in the Chancery?
No, before proper case management.
Yeah. I shouldn't be saying the phrase "those were the days," should I? Page 1596. There's a just to make good the point that this draws on the same well, if I can put it that way. You see this reference back to Hilton Westminster Bank. Lord Justice Atkin passages are referred to by the first instance judge here. And then also the passage I referred you to of Lord Dunedin, or Viscount Dunedin's speech at 1598, B through to E, and supporting the idea that what we're looking at is in reality what the customer wishes. And then the sort of conclusion from all of that recitation of authority at 1599D, the adoption of the phraseology used by Banks LJ in terms of the formulation of the duty, and that the test of care requires is the performance of the bank's duty as an objective test of reasonableness. And then we have 1604, the rejection of matters being peculiar to banking law particularly, so they're going out even wider as a general law. So we can see that, for example, the marked passages, second marked passage at 1604E. And then banking practice not being a separate body of law, page 1607, G/H. And then we see at 1608B, standards and objective standards applicable to bankers. And then we see the relevant factors at B to E, and then the summation 1609. And then we have carrot rubber. Sorry if I'm going too quickly, but I'm just trying to be as quick as I can. This is behind tab 10. Mr. Justice Brightman, as has already been observed, gave judgment finding someone was in breach of duty to exercise reasonable skill and care. You can see that from the holding, page 605, holding number 1. So the E-bundle, if you're not there yet, is 262.
Yeah.
And there's the observations about the extraordinary nature of the transaction, which is obviously the sort of second part of things at holding 2. And wanted to just briefly draw your attention to the fact that, of course, by this stage we'd had a reasonable body of case law already established supporting the notion of a reasonable skill and care duty, and that facts out of the ordinary are normally an indicator of a need for a reasonable person to investigate further. And you can see that this is then attacked as a concept for Mr. Justice Brightman by the bank. You can see Mr. Kaplan on behalf of the bank makes out his submissions starting at 624, D and onwards. And you see similar themes there, which are obviously ultimately rejected, being deployed in this case. And then at the bottom of 628 over to the page 629 is the phrase, in my view, the Achilles heel of the bank's argument. If you could just read that to yourselves briefly. you may think some phrases there are phrases which, using different language, the bank is seeking to.
It's that point that he makes, isn't it, at C on 629, which he comes back to in the passage at G, where he says at C, once a bank disclaims the untenable position of being in all cases an automatic cash dispenser, whatever the circumstances, there's no rational stopping place, short of a contractual duty to exercise such skill and care as would be exercised by a reasonable banker in similar circumstances. And that care and skill must rationally include inappropriate circumstances, a duty to inquire before paying. And he comes back to that at G, where he says, in my view, the proper question is whether suppose we could put the paying banker and customer, whether the banker is to exercise reasonable care and skill in transacting the company's banking business, including the making of such circumstances as may, in given circumstances, be appropriate and practical, etc.
Yeah.
So it all depends on the facts.
And the reasonable industry practice at the time. Yeah. So I mean, let's test where we got to by some scenarios, and I should pay credit to Paul Downs, Queen's Counsel, for at least one of these, is suggesting a potential scenario for stress testing the proposition advanced by the bank in this respect. Let's look at scenario one. Mrs. Bloom runs a florist as sole trader. The business banked with Bank West for a number of years. She's a keen environmentalist and subscribes to a climate emergency campaign. Last Tuesday, Mr. F, the fraudster, persuaded her to phone her bank manager to transfer 1 million to Green Matters, a company based in the Comoros Islands. Mrs. Sloppy, Mrs. S, the bank manager, is suspicious. She does a Google search, finds out that Green Matters is being investigated by the FBI, NTA, and other agencies for fraud. Mrs. S meant to stop the payment but forgot, and the payment goes through. So, would the bank be liable for Mrs. Bloom's loss on those facts? Well, we would respectfully submit, if you look at the phrase whether the duty is in and about the processing of the customer's transaction, that it's undoubtedly the case that the bank manager was negligent in and about performing the payment instructions, and liability should be recognised. But on the bank's case, no. Let's give it a twist. Let's assume that, as I said a few moments ago, that the sole trader in question asks her husband, an agent, to organise payments on her sole trader account. He's persuaded by a scammer that the money should be moved, and he contacts the bank to instruct them to do so. Let's assume the bank knows or has reasonable grounds for believing that it is a scam. So on that set of facts, they are on notice that the instruction is likely to be inconsistent with their customer's true intentions. As we understand it, the bank would acknowledge liability on that set of facts. It has knowledge that the instruction received from the agent is not likely to be what its principal wants. So the same fraud, APP fraud, has caused the loss with two very different outcomes. It's just not rational, we submit, or in any event, to put it for a lower threshold for the purpose of this case, we have a real prospect of showing it's not rational to make that distinction. And we end up on our submission with inconsistent and unjustified disheartening. Concurring itself, I think, probably is known so well that I can probably take it pretty quickly, but it's the next case in time, and there was an attack on the statements of principle as laid out in the earlier cases in Concurring, and so we get a sort of a detailed consideration, obviously, of matters as a result. And rather than take you to the case, perhaps if I just give you some brief points which we say we take out of Concurring, and if we need to dive into it, we can, because I think we've already given you the key references in our skeletons already, and I've taken you to the main passage. But the first point we say is It's at the heart of what Queen Square does is a recognition and application of general agency principles that an agent must take reasonable skill and care in the performance of services. And this applies when they're on notice of fraud, even if it might otherwise be required to make the payment in accordance with the mandate. Secondly, that in rejecting the bank's attempted assault on the proposition, the judge looked at policy factors. On the one hand, that the law shouldn't impose too burdensome an obligation on bankers, and on the other, the law should guard against the facilitation of fraud. And the landing point was a reasonable standard of care in order to combat fraud and to protect bank customers. That's the same landing point as the House was in the Court of Appeal in Hilton and the earlier cases. Would an ordinary group bank have reasonable grounds? That's a statement of general principle applicable to all types of fraud. It has nothing to do with, at its heart, the general principle to do with just want of authority. As I've already noted, at 376H, there's the passage about industry approach being influential. My fourth point, it's not and never has been the case that the duty to exercise reasonable skill and care ceases to apply if and when an authorised instruction has been given. That can be shown by reference to the fact that the duty applies where one is considering a case where the bank has received a valid and proper order, which is prima facie required to execute promptly or risk incurring liability. And you see that concept incorporated in Mr. Justice Steen's judgment by reference to these words ex hypothesi, the quote at 376. It's the same quote at 376, the passage I took your lordships to. I don't know if the point is clear from what I'm saying is, but by dint of the fact that the duty is triggered in cases where the bank is put on notice, the mere fact of authority is not determinate as to whether loss of liability is established.
Yeah.
There's nothing about the reasoning which restricts it to just simply the case of for want of authority. And of course, the Queen Square duty, as subsequently referred to in later cases in Singularis, etc., is referred to in that context. Fifth, Mr. Justice Steen was not saying in all cases the duty to exercise reasonable skill and care is subordinate, but generally speaking it is. Same point that I've made by reference to principles I've already identified. Again, if the circumstances of the transaction are unusual or such as to give rise to something that an ordinary bank would consider needed to be looked into, then it isn't. Next, Lipkin Gorman in the Court of Appeal.
Just before we go to that,
Yeah.
just on Quince Care, could I just ask you something that
Sure.
I'm sure it's my fault, but I didn't quite understand. If you go in the judge's judgment, please, in paragraph 133,
Yeah.
this appears to be where the judge accepts the bank's submission that the existing authorities, but he's got Quince Care obviously very much in mind,
Yeah.
limit the duty to cases of attempted misappropriation by an agent of the customer.
Yeah.
In my judgment, they do confine the duty to that situation. leave aside the questions of duty, if I've understood your submissions correctly, you say that what happened in Quintscale was just an aspect of the general overarching duty of care.
Absolutely.
It's an example.
It's a specific factual category.
And whether that point might not have been put, to be fair to the judge, that point might not have been put precisely to him in those circumstances, but in that form. But when you look at the judgment, there's an awful lot about the Quintscare duty, and certainly looking at it from first principles, speaking entirely for myself, there seems to be quite a lot of force in the proposition that this is an example of the duty, the general duty, and obviously the facts are different, because that is attempted misappropriation by an agent of the customer. But in one sense, so what?
I concur.
And so in some ways, I think that some of this stuff may be down the wrong track.
Yeah.
Because your basic submission, at least to us,
Yeah.
is that Quintscare is simply an example of the duty that's identified in a number of cases on the facts of that particular case.
Yeah.
And what it has in particular, of course, is it has it has Mr. Justice Stein, as he then was, identifying what the middle ground was.
Yeah. So he was saying, look, there's obviously
It's not that could be extreme, that could be extreme. The middle ground is this, and it's supported by the banking.
and it's an objective, reasonable standard. It has nothing to do with constructive knowledge in relation to dishonest assistance cases. It's negligence is the standard, really.
Yeah. I understand that. You'll see why, therefore, I just queried that.
I think you're absolutely right. It's an incorrect conclusion to draw that they limit the duty. They are simply an example of the application of the more general duty.
And Mr. Justice Stein wasn't seeking to, as I read his judgment, limit the application of the duty to corporate customers. He was simply dealing with
What was before him?
what was before him, which was a case of a corporate customer. But if you'd said to him, what you said at page 377 and where he deals with, for example, Sanderson and Clay, well, none of that would ever apply between a banker and an individual customer. I think I know what the answer would be.
Yes, when the
If
question
I made that submission to him, I know.
when the question is
He
put
would have said to me.
when the question is put to the hypothetically by Mr. Justice Brigton, Carrot Rubber, for example, the Achilles heel. If the bank knows of fraud, it's got nothing to do with the particular facts of that misappropriation. It's just, well, if you know of fraud, are you really saying that a reasonable banker wouldn't do something to try and prevent it? That's the in my submission where it comes from, not the
Well, in a sense, if you go back a page to what the judge said about the evidence of Mr. Redhead and the example of the £350,000 transfer to a local casino, and he would have queried that and certainly wouldn't have allowed it to be sent without further inquiry. That, one suspects, the answer would have been the same if he'd been dealing with an individual customer's account, which individual customer, like your client, had never paid sums of money of that size, let alone to a local casino.
And the reason why this would be so retrogressive if it got crashes is because the personal retail customer is the most vulnerable. They're the least sophisticated. And of course the bank gathers in a huge amount of information, useful information to them and their customers more generally about potential fraud.
Yeah.
Now, I was going to move on to Lipton Gorman briefly in the Court of Appeal because for reasons which we don't quite understand, the judge thought it somehow supported the conclusion he arrived at.
Okay.
It's Authorities Bundle tab 12 you want the e-bundle reference for it, it's 332. Now, obviously, this is probably better known for the principles in relation to restitution and unjust enrichment, etc. But there's some discussion as regards general principles by the Court of Appeal, and there are two passages I was going to take you to. First was that of Lord Justice May at page 1354, and you'll note that probably part of what's said is strictly unnecessary. You can see that from the words starting at just between E and F. In circumstances in this case, it may be strictly unnecessary to consider the views expressed in these cases. And then we can see then the general observations at 1356 with the part that we quoted. For my part, I'd hesitate to try to lay down any detailed rules in this context. I don't know if your lordships are there or not, but there's that paragraph which I was going to then take you to next.
Sorry, which paragraph?
It's 1356 within the internal report. That's the sidelined passage E through to G.
Well, I suppose Mr. Goodall I'm sure will rely on what's said by Lord Justice May slightly earlier on, where he deals with Selangor and Burden. He says that the judges in those cases stated the duty too highly. Bottom of 1355. Principal obligation on the banks to honour customers' checks in accordance with the mandate. Nothing in such contract, express or implied, which could require a banker to consider the commercial wisdom or otherwise the particular transaction.
Yeah, but we're not dealing here with the commercial wisdom of investments. What we're dealing with here is notice of fraud. Quite a different.
That doesn't seem to me, at least, to be dealing with a situation where the bank's at least arguably put on inquiry.
And he endorses that principle at 1356 at F. He indicates, obviously, he hesitates to lay down any detailed rules. The reason why I was going to take you to this passage is because it is a passage which the judge himself referred to as somehow against us. I didn't ever quite understand why. The judge refers to this in paragraph 160 of his judgment in rejection of the notion that there's some sort of duty. Because the judge here said not to lay down any detailed rules in this context. And so I think the judge's point was, well, you're trying to lay down detailed rules by your pleading of the duties in paragraph 61. So therefore you're doing what's contrary to what the judge said here, which is not what my interpretation of this paragraph is about at all.
Do we get anything out of the other judgments?
We do. I think, in fact, the leading judgment is that of Lord Justice Parker, and his judgment starts at 1360, that's E 352, but it's the marked passage with heading the law at page 1376, which is the leading judgment, which was concurred in by Lord Justice Nichols. See if you want to reference that 1387. But the passage by Lord Justice Parker, 1376, is in our respectful submission bang on, and we would endorse what he says there from A through to E.
Well, shall we read that to ourselves?
Yes, please.
Perhaps we'll break.
It may help if I just briefly finish this case before the short agenda.
Okay.
I was also going to invite you to look beyond the quote from Mafani to the passage marked G to H as the warning of blurring between constructive trustee principles and liability for breach of contract. And then this assumption as counsel obviously appeared in first instance in the Court of Appeal, and the judge is making the point here. Sorry, if I actually given you the page reference, we're over the page now. The next marking up 1377.
Yeah.
It's sideline D to E, if you can read that as well. So this isn't about want of probity. It is well, you can see there, it's about negligence.
Well, in a sense, the point my Lord Justice Coulson puts you in there, alleges that from 1378 at B to C, isn't it? The question must be whether if a reasonable and honest banker knew the relevant facts, he would have considered that there was a serious or real possibility that his customer might be being defrauded, or in this case, that there was a serious or real possibility that cash was drawing on the current account and defrauding the beneficiaries of the money.
Absolutely.
He's giving that as an example of the wider
The subset.
duty.
Absolutely. And as I said, we then have the concurring judgment of Lord Justice Nichols at page 1387 at C.
He dissented in the result though, didn't he? I think.
I'll check that point of the short lecture adjournment, but
Yeah, I think
you may be right, but for present purposes,
well, the head note says he dissented, so
yeah.
either I'm right or the head note's wrong.
I'm looking for his expression of regret or sadness. That's usually what you get.
Yeah,
That couldn't-
but I think the point that I was trying to emphasise here was on this reasoning, if you like, this line, the bank's cross appeal.
No, you're absolutely right. You're absolutely right.
It's a C, isn't it?
So
Yeah.
if you go to 1387, let's see,
Well,
the reasons given by Lord Justice Parker would allow the bank's cross appeal dismissal as
Exactly. Yeah. So key points then. I think we've already probably dealt with them with argument already, and I don't need to repeat them.
Right, is that a convenient moment?
Yeah.
So 2 o'clock.